Hi, I'm Steve Richardson, and this is the April 2018 episode of Lunch with a Lawyer. Today we're going to talk about a new program in New Jersey for veterans. And it's a great program, and it really recognizes a lot of the problems and issues that service members in our military and our veterans have, and really take an enlightened and compassionate approach to these issues through this program. And it's called a diversionary program. Now, I've talked about for diversionary programs in early episodes of Lunch with a Lawyer as ways for people that at first time brush with the law, that they've gotten in trouble, that they can avoid some of the more serious consequences of their actions under the criminal code. Disorderly person's offense, petty disorderly person's offense, that sort of thing, depending upon the charges. And those are one-time bites of the apple for your first-time offense to, as I said, avoid some of the more serious consequences of a criminal charge or criminal conviction. Now, I talked about conditional discharge, which is a program that is designed to help people facing drug charges where they have a small amount of marijuana, usually marijuana that's for personal use, and they get caught with it in their possession. Through a conditional discharge, they can avoid a lot of the punishments and sanctions for a drug possession charge. There's also a conditional dismissal, which is used in instances where, for example, shoplifting and some other non-violent disorderly persons offenses, where you can avoid, again, the consequences. And also for more serious crimes that are handled at the county level by the county prosecutor, there's something called pretrial intervention. So what I'm going to talk about today is a veterans diversionary program, specifically for service members and veterans, as opposed to one of these other diversionary programs. And as we learn more and more about things like PTSD, post-traumatic stress disorder, and other mental illnesses and problems that our service members and veterans have, as I said, this is a very enlightened program that really recognizes that and realizes that these people who have served our country need help, not criminal sanctions. So, first question is, who's the program for? Well, as defined in the statute, it's for service members, and a service member is an enlisted person or officer in the U.S. Armed Forces or reserves of that branch, a member of the organized militia of New Jersey, National Guard, or a veteran, an enlisted or officer honorably discharged or released from service. So either an active duty service person or someone in the reserves or someone that's got an honorable discharge or separation from the military. Now, that's who qualifies. Now, what offenses qualify? Who they are, now what they do. Non-violent offenses that are either disorderly persons offenses or petty disorderly persons offenses, what other states would call a misdemeanor, or a crime, what other states would call a felony, of the third or fourth degree. So not murder, kidnapping, a lot of the upper level armed robbery, very serious charges that can be brought. Now, so you have a service member or veteran who has been charged with a non-violent disorderly persons, petty disorderly persons offense, or third or fourth degree crime, non-violent, but they also have to suffer from some mental illness. Now, they have to have a prior diagnosis of a mental illness. Well, that's the clearest evidence. Right? Or a law enforcement officer or prosecutor who has a reasonable belief that the person has a mental illness based on behaviors and symptoms exhibited during the commission of the offense or while in custody. All right, so they're exhibiting some signs, even though they may have gone undiagnosed, they're exhibiting some symptoms and behaviors are consistent with it. Or based on information provided by family members or associates during the investigation of the offense. So it can be diagnosed or it could be undiagnosed, but observed by the arresting officer, police, or prosecutor, or it may just be a family member that comes in and says, "Hey, look, this guy's suffering from PTSD or some other mental illness," and we'll get into what illnesses qualify, and you should really look into handling them in a different way through this diversionary program. Now, that begs the question, as I said, what's a mental illness? All right, that's the next question. Well, the statute that creates this diversionary program defines the term, along with a lot of other terms. It's a mental disorder classified within the current version of the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Disorders, often referred to as the DSM. You may have heard that in the media or on police procedural shows. Including, and they give examples, and a non-exclusive list of examples, including but not limited to anxiety disorders, cognitive disorders, adjustment disorders, schizophrenia and other psychotic disorders, bipolar disorder, depression, and PTSD. That's a pretty wide list, but it does give you a good idea what they're talking about by mental illness. And obviously this is, say, hey, look, if a crime gets committed by a service member or veteran, because they're suffering from this mental illness, they don't need punishment, they need treatment, they need help. And the whole purpose of this statute is to direct those service members to the help they need and get them out of the criminal justice system. So it's a very important program. So more to it, obviously. There are different times and different points in which this program can come up. And interestingly enough, a duty is placed on the law enforcement officer, on the police officer, the arresting officer, to look into this. Okay? Following the arrest, the officer must ask as to whether the person is a service member or has ever served in the U.S. Armed Services, so military services. So they have a proactive duty to ask that question when they arrest them. And if that is determined from questioning, and the officer observes behaviors or symptoms that may be related to mental illness, so they say, are you a veteran? Are you a service member? Yes, I am. And in this interaction during the arrest and things like that, started exhibiting symptoms, then he may process the arrested person through the diversionary program, but with a preference to sending him or her to a veterans diversion resource entity or other community-based mental health services rather than filing charges. Basically, getting him the help that he needs. So that's important. Now, he may process the arrested person through the diversionary program, but with a, as I said, with a preference to do that. Now, there are, this won't happen, okay, at least at this stage, if the crime or offense involves restitution for damages, violence or the threat of violence, and by what I mean by the violence or the threat of violence, the victim sustained a bodily injury, and that's defined as being physical pain, illness, or impairment of physical condition. The defendant was armed with a deadly weapon and either used it or threatened by word of gesture to use it, or threatens to inflict a bodily injury. It also won't happen if the violation, the crime that he's accused of, is violating a restraining order or protective order involving another person. And finally, if the victim objects to the diversion. So that, as I said, the process, the whole thing can start at the time of arrest. So that's that. Now, it can also happen after charges are filed. Okay, there's already been an indictment, there's a prosecutor involved, and this can happen. So maybe the person didn't exhibit the symptoms at the time, but it can come up later, and maybe a family member comes forward and says, "Hey, look, this person is suffering from an anxiety disorder, an adjustment disorder. He's bipolar and needs office meds," or whatever the reason being. Brings it to their attention, and so that the defendant can do it, or his or her attorney. Now, there's a certain, in order to qualify for this diversion, there are some strings attached. All right, you don't just get into the program and get the treatment, but the service member has to agree to certain things and has to agree in writing to the following terms where relevant. Has to agree to participate in case management and mental health services and to cooperate with any recommended course of treatment, including the use of medications as prescribed and participation in counseling. So we're going to get you the help you need, but you need to take advantage of that offer. You need to take advantage of this help. You need to let them help you. Okay? You can't offer it and you don't take it. Well, they tried, but you're going to have problems. You have to agree in writing to that. You have to authorize the case management or mental health service provider to release to the prosecutor periodic status reports regarding your participation, cooperation, and recovery progress with case management and mental health services. So you, because of all the HIPAA laws and everything else with treatment, you have to allow that to be released to the monitoring agency, to the prosecutor, to make sure you're doing what you're supposed to do and cooperating in the program. Cooperate with case management service providers to procure housing, education, and employment services where appropriate. Pay restitution for damages that have resulted from the offense. Refrain from use of alcohol or illegal drugs or frequent any place where alcohol or illegal drugs are sold and used. All right, so there are certain restrictions, like being on parole, that you need to observe in addition to treatment. In addition to refrain from the possession or use of firearms or other weapons. Of course, refrain from further criminal activity. Okay, this is to help you don't keep committing crimes. Refrain from any contact with the victim of the offense. Leave them alone, okay, especially if it involves another person, not a crime against a person as opposed to property. Cooperate with a mentor where assigned, and the U.S. Department of Veterans Affairs Justice Outreach Specialist, so there may be someone other than the prosecutors overseeing your progress in treatment. You need to cooperate with them. You need to agree to suspend the tolling of time for the purposes of the service member's right to a speedy trial while the service member is participating in the program. So what that means is you're saying, look, I want to get into this program. I want the diversion. I don't want to be involved in the criminal justice system and face those punishments. But at the same time, I can't claim, hey, you didn't fail to prosecute in a timely manner, and that violates my constitutional rights to a speedy trial. So you can't go saying that either. I mean, fair is fair. Advise the prosecutor of any change in his residential address or any change in the provider of case management and mental health services. Again, just like being on parole, let them know where you are, let them know where they can contact you. And finally, any other terms and conditions related to the service member's recovery and public safety deemed appropriate by the prosecutor. So sort of an open-ended catch-all that can be done on a case-by-case basis as to what may be determined as being needed. So those are the things that you'd have to agree to in writing to take advantage of the program. Now, there are further things to bear in mind. The prosecutor shall determine the duration of the service member's participation in the program. How long does this program last? Well, it can't last longer than 2 years. Okay, so total, it can be less than that, and we'll get into that in a minute, but no longer than 2 years. Now, the term of the service member's participation, okay, how long it can be, as many as 2 years, is based on the initial clinical evaluation and recommendations, so it's going to be evaluated by a mental health professional. Status reports of the service member's participation. Are you cooperating? Are you doing your part? Are you doing what they're telling you to do to help you to get better and help you to get the treatment you need? And progress reports from the case management and mental health service providers, and where assigned the service member's mentor. Sometimes a mentor can be assigned to this program. The service member is responsible for coordinating with the mental health service provider to ensure that the prosecutor receives periodic reports on participation, cooperation, and recovery progress. Help them help you and report to the overseer. You must contact the mental health service provider within 7 days of the date of the diversion agreement. So you need to kick things off. Once you get into the program, you need to contact them within a week to get the ball rolling. All right. Now, there's a minimum of 6 months. After this minimum of 6 months, from the date of the diversion agreement, the prosecutor is satisfied that the service member has complied with the terms and conditions of the diversion agreement, has not been the subject of criminal charges, don't get in trouble again, all right, and based on clinical reports, continues to make progress with the case management services and mental health recovery, then the prosecutor may move before the court for the dismissal of the criminal charge pending against the service member and terminate the program. So after 6 months, prosecutor takes a look. You may not need 2 years, all right? After a minimum of 6 months, maybe you're getting your help you need, and you're cooperating and everything's fine and you haven't gotten in trouble, then the program may end there and the charges get dismissed. Okay, just like conditional dismissal, just like conditional discharge, pretrial intervention, these other programs, diversionary programs that I talked about, charges can be dismissed. Alternatively, all right, if that's not the case, the prosecutor may require that the service member continue participation in the program until sufficient evidence of progress towards recovery is available, except that continued participation should not exceed the 2-year limit. Okay, so 6-month term, I guess, renewable 3 more times for 3 more 6-month terms, but the prosecutor can extend it just not longer than 2 years. But if at any time the prosecutor finds that the service member has failed to comply with any term or condition of the diversion agreement, the prosecutor may notify the court that the state is prepared to proceed with the prosecution of the offense, and the court shall schedule court proceedings as appropriate. So if, on the other hand, they find you're not doing what you're supposed to do, you're not getting any better, you're not making progress, this ain't working out, then he can say, no, never mind, we're going to proceed with charges after all. Now, there are no fees for this. No fees are assessed to the service member for participation in the program, which is good. Other programs like conditional discharge have fees, so that's good. There's no fees. Now, an eligible service member may be admitted to the program 1 or more times at the discretion of the prosecutor, subject to certain restrictions, if such diversion promotes the service member's recovery, prevents the commission of future offenses, and protects the safety of the public. So you may have to go through this program more than once. Again, if you meet the qualifications and it's easy, yeah, you need more help. So an eligible service member can still apply for admission to a criminal justice diversion program. So those other programs that I talked about are still available. Okay, you can opt into those as an alternative to the veterans program to the extent that the service member meets the eligibility criteria and qualifies for those programs, including a program for supervisory treatment, conditional discharge, or conditional dismissal. So just because you're a service member and meet the other criteria doesn't mean you necessarily have to jump through all the hoops and do everything you need to do under this other program. You can still use the one-time only programs that I mentioned. A dismissal of a criminal complaint resulting from successful participation in the program shall bar service members' subsequent eligibility for such a program. However, an eligible service member may seek subsequent admission to the Veterans Diversion Program and may be admitted at the sole discretion of the prosecutor, so it becomes a discretionary thing. Now, dismissal. Here's some more good news once it's dismissed. The dismissal of charges based on a service member's successful participation in the program shall not be deemed a conviction for purposes of disqualification or disabilities, if any, imposed by law upon conviction of a petty disorderly person's offense or disorderly person's offense or a crime, but shall be reported to the State Bureau of Investigation criminal history record information files for the purposes of determining future eligibility or exclusion from other diversion programs. And what that means is that that participation in the program and dismissal of the charges doesn't carry the taint that may disqualify you for certain jobs, things like that, and sort of goes away. But it's still there if you try to get into another diversionary program. It still can come up for purposes of qualifying for that other diversionary program. Also, it shall not be deemed a conviction for the purposes of determining whether a second or subsequent offense has occurred under any law of the state. So some laws, the punishments get more severe for second and subsequent offenses and are less for first offenses. If there's a dismissal on this program, doesn't count. If you get charged again, you have to face the consequences of that charge. This charge does not count for sentencing as a prior offense. Now, finally, and just get into charges can still be filed after a diversion if the service member fails to cooperate with the provider of mental health services or has subsequent interactions with law enforcement and the appropriate statute of limitations has not passed. Depending upon the seriousness of the crime, there's an appropriate statute of limitations. So they can still proffer charges, et cetera, as long as the statute of limitations has not passed. So that's the Veterans Diversionary Program in a nutshell. There's more to it. There's some other stuff under the statute that you can really get into the weeds, and I think you don't want to know. And if you really need to look into this program, or it may apply to you or to somebody in your family or a friend, then you need to talk to an attorney who can advise you on some of the other things that may be brought to bear as part of the program. But these are the main issues you need to look at. Now, that gets you through that program, you complete the program, charges are dismissed, and you move on with your life, hopefully better than you were before. But there may be issues you might want to expunge that arrest of that whole incident. There have been some changes to expungement based on this program. I'm not going to get into that here, mainly because I'm going to be doing a future episode of Lunch with a Lawyer on expungements and stepping through that. So I'll deal with it at that time. So you'll see on my Facebook page an announcement of that event when that comes up. It'll probably be I believe the May or June episode of Lunch with a Lawyer will be on expungements. And you can see that because there are changes coming up in expungement law. I may wait to do that until after those changes come into effect. But stay tuned. More information on expungements. For right now, this is the program. But that's it for Lunch with a Lawyer for April of 2018. I hope this was informative for you. If you like this program, please hit that like button, hit that love button, interact with it. That helps with the search results and helps Facebook's algorithm get this program out to more people and helping more people. And again, these are for New Jersey residents. This is a New Jersey program, so if anybody's viewing from outside the state of New Jersey, this doesn't apply. And of course, with the caveat that if it does apply, if you might help from it, this is really an informational program. This does not replace a consultation with a lawyer. It is not legal advice. Please bear this with a grain of salt. You've learned something today, hopefully, and that will educate you to pursue this course of action if it's helpful for you or someone you know that's a service member or veteran suffering from a mental illness. Now, this program is also available for replay through my Facebook channel on Facebook, facebook.com/Richardson Law Offices. It will also be exported out to my YouTube channel at richardsonlawoffices.tv. That will be in the next week or so, and if you can see it again through YouTube. If you like the YouTube video, again, thumbs up and like the YouTube video. That helps with search results as well on YouTube. And also, if you if you really like the content of the channel itself, I'd encourage you to subscribe. You can do that by clicking that subscribe button to get notifications of additional content. So that's it for this month, and I'll see you next month.